it worries me when I don't hear the music at the beginning, because a lot of times that's when there's a technical problem, and I didn't hear the music tonight. Did you guys hear the music when I had the mic off? Okay, it's looking like yes. Okay, well, let me text Ship. I sent him a message, but let me text him and see if he's going to be able to join. I think he might have been going to be a few minutes late. But let me remind him that we're on for tonight. King, while I'm doing that, why don't you fill us in? How are you doing where you are?
Oh, I'm doing great. Thank you. I'm not in Western North Carolina or
Right.
Eastern Tennessee.
Right, exactly. It went around you guys this time, didn't it?
Yeah.
So, yeah. We got a bit of rain here in southeastern Virginia, but that was all. So, the folks in North Carolina are having a hard time, it looks to me like. So, hopefully, everyone is staying safe tonight. I've got Hubs here with me tonight, and we've got 4 topics I want to cover tonight. Um, Eric Adams, P. Diddy, Sean Combs, Hunter Biden a little bit, and DJT, of course, the former president, and his cases. So, because there's been developments uh, on his front. So, let's see, what should we start with, especially while we're waiting for Ship? King, what do you recommend?
Oh, just flip a coin.
Okay. Well, did you read the indictments for Eric Adams and Sean Combs?
I did.
Okay,
Uh,
fantastic. And so let's start with then um, Eric Adams. Okay. Wow. All right, you guys. So Eric Adams is the sitting mayor of New York. Is he still the mayor as of tonight? Steve says
last,
yes.
yeah. Last I heard, he is. Uh, he and his lawyers came out fighting when this
Yeah.
indictment came down.
Yeah. All right. Bill has texted me back. He says he needs 2 more minutes. So he is joining. All right. Well, so they had his initial appearance in the U.S. District Court, Southern District of New York, which is in Manhattan, I believe, on Friday morning. And they didn't do too much. That's usually some districts do it this way in federal court. The initial appearance is basically to make sure that the person has a lawyer and that they understand that they have a case and they have to start coming to court and blah blah blah. And then they set an initial conference for next week, October 2nd. And I'm not a New York lawyer, and I had, over the course of my career, only a few cases in federal court, even in New York. Oh, there's Ship. Ship, I'm going to send you a co host invite. So New York does things a little bit differently, even in the federal system. So maybe Ship will know a little more about this as to did they take a plea on Friday, or are they going to wait to actually enter a plea on Tuesday? Ship, do you know? Good evening, Ship, by the way. You got to unmute yourself. There you
Oh,
go.
yeah, yep. I'm actually. The question was, what are they doing in New York next week?
Right. Well, they had an initial appearance for him on Friday morning, but the docket just reflects that they did that, and then they set an initial conference next week, October 2nd. What is that going to be? Wednesday?
Well,
Um,
he's been indicted, so the initial
right.
appearance would have actually been an arraignment plea, not initial appearance. So they likely do those. Unlike D.C., which is the only court I know that does this, arraignment plea is probably done before the magistrate. And then the first
Yeah.
conference for next week is going to be the first conference with the district judge.
Right. And that makes sense because, again, this is why it seems unfamiliar to me, because it's not really the way that it's done in DC. Um,
Which is
the
maybe the only place in the country that I know of that does it the way they do it in D.C.
Right. Um, and normally when I was in Maryland or Virginia cases, I would be coming in either way earlier than this or after this. So I wouldn't normally be handling this part, although I did a few times. But I did this more regularly in DC. So the docket reflects that Adams's lawyers tried to get the district judge to kick over the initial appearance also. They sent emails to Chambers saying we rather would appear in front of you next week because the scheduling, whatever. And the district judge rebuffed that. He put a, or she, I think it's a he, put on the docket that, well, you're going to be doing your initial appearance in front of the magistrate anyway. So I don't understand why you're talking to me about your schedule. And I'll see you next week for the initial conference. So do we know anything about these lawyers that Eric Adams has? Maybe they're not New York lawyers. That seems strange, but either one of you guys know anything about them?
He's got Alex Spiro.
He's got Alex Spiro. Okay.
Yes, of Quinn Emanuel. And he is a well-known, high-profile, big firm defense attorney.
Is he from New York?
I don't know if he's from the New York office of Quinn Emanuel or the West Coast office.
Well, based on what's on the docket, I would guess he's a California lawyer. I would have expected a New York lawyer to know that.
He defended Alex Baldwin.
He defended Alex Baldwin, Steve says. Okay. So he knows what he's doing, but maybe not procedurally how things are done in New York, which could be a handicap in New York. So, okay. Well, so Eric's hired himself a good lawyer. Ship, your comment?
Well, I don't. I mean, I expect they'll have somebody else join that team now that it's filed. Although they've known this was coming for months, I'm, pretty confident.
Right. Okay. So let's talk this over. The case itself is, well, okay. There's a lot of, you took money from people and you didn't disclose your travel, but that would be a New York charge, the failure to disclose. He's not charged with that. This is in federal court. He's charged with wire fraud and soliciting illegal campaign contributions, which is against the law. It's a federal offense, even though the election may not be a federal office. So, okay. And there's conspiracy, of course. Soliciting contributions by foreign nationals, that's against the law. And then bribery under 18 U.S.C. 666. So, what do we think of this as a federal case as opposed to a state court case? Let's start with that.
In my opinion, it is Damian Williams paving the way for his own run for something in the not too distant future, maybe Schumer's seat. This is.
Well, so let me stop you there. For folks who don't know who Damian Williams is, explain that a little bit.
Damian Williams is the U.S. Attorney for the Southern District of New York.
So he's the federal prosecutor. Yep.
Mm-hmm. Correct. He is Harvard, Yale law grad, Harvard undergrad, Yale law grad, son of Jamaican immigrants. Was in the U.S. Attorney's Office for 9 years. Clerked for Justice Stevens on the Supreme Court.
So he's a smart dude.
Yeah, and has always been kind of tagged as politically ambitious.
Okay.
And was nominated or recommended for the seat he's in by Chuck Schumer, and has always sort of run in those circles. And he's there's going to be a lot of people jockeying to be the next mayor of New York, and
to be the next senator from New York,
and the next governor of New York, and the next senator of New York. So you've got 3 high-profile seats that are going to be open, in the very near future. And I'm confident he has his eye on one of them.
Do you think that they didn't approach the state prosecutors' offices at all to see if they wanted to prosecute him first? Because this reads like some slam dunk easy state court felonies to me.
That's what I kept thinking as I'm reading, is why isn't this a state case? But I think there's rivalry there. He doesn't want to hand it over to Alvin Bragg, and he doesn't want to hand it over to Letitia James, so he kept it himself.
Right.
He is the same guy that just indicted,
P.
Sean
Diddy.
Combs,
Yep.
convicted Bob Menendez. He's collected scalps. He's going to have the bona fides as not necessarily being, or as not being, the Soros-backed DA.
Right. Well, I mean, since the beginning of this country, prosecutors have had political ambitions, and a way to make yourself known. There's nothing wrong with this to the population is to be a prosecutor, right? And
Yeah,
then you become a judge or you become a politician. That's the way it
and
goes.
he is, and he has not. He's not in any way. He's going to be very difficult to tar with the idea of he's only goes after political enemies, whatever. He indicted the lieutenant governor of New York, who was an African American guy. He indicted I think the guy's last name was Silver, who was the head of the New York State lower house of the legislature,
Right.
as a Democrat. So he hasn't
Adams
played
is
favorites.
right.
And, and Adams is sort of clung to the opposite polar end, although Adams has got a really odd history. That guy's
Yeah.
the guy about the only thing the guy's not wearing is an actual clown nose.
Have you ever heard? I know you're not bosom with him anymore, but have you ever heard Dan Bongino talk about Eric Adams?
No, I haven't.
It's worth a listen. Because Adams was a police officer, right? So was Bongino in New York, and he talks about how Adams is one of those guys where you were going to be seriously injured if you tried to get between him and a camera.
Yeah. That he's always been a shit stirrer. He's always been a self promoter. I mean, he actually, I think it was when he was on the NYPD and had like 10 years experience. I think he was on NYPD from like 1986 to 2000. He was there for 22 years.
Right.
And even when he retired under a cloud of controversy.
Mm-hmm.
He was sort of ushered out the door. I don't know really what the story is, but yeah, in like '96 when he was still in NYPD, he filed papers to run for Congress, and didn't get the necessary signatures or whatever was required, and didn't make the ballot.
Permission or whatever, right? Well, and he's a Democrat too, so the prosecutor here he's not just going after Republicans. Far from it. Of course, most of the Democratic political establishment, I'm sorry, the New York political power base establishment at the moment is Democrats, right?
Oh, but they're happy to be rid of Eric
Yeah, of
Adams.
Adams. Yeah.
There's a handful of people, and one of the issues as I was reading through the indictment, and I had written a subsectory last week about the generalities that litter the Sean Combs indictment. There's
Oh yeah.
not a single specific allegation in damn near the entire thing.
Right.
In a RICO case.
Right. We're going to get to that, but I agree with
Yeah,
you.
yeah. So, but this thing reads like a dime store novel, the Eric Adams book, and it's
Right.
like, and it's just so transparent. The effort is to either give the governor, she has the authority under New York law, to give the governor the sufficient foundation to push Adams out of office, which she can do,
Right.
or
Well,
to
her
force.
office came out immediately and said he should resign, right?
Yeah,
And it's because of the specificity. This is your point of
right.
what's in here. It's not like these are he did some bad stuff. This is like, no, he
Yeah,
solicited contributions from foreign nationals. He didn't list his travel. He took money that ended up being matched by the New York fund, and he's defrauded the state of New York by like $8 million, $10 million or something. So, right. So Kathy's not unclear about what it is that Eric's allegedly done.
right. And his rivals now who want to run for the office in 2025 in the next election, they want him out too. They don't want to run against him as an incumbent.
Right.
So that's the level of specificity, which is a little bit disappointing in the sense that the appointed U.S. attorney, who doesn't seem to have any real skeleton in his closet that I could find, essentially engages in a political hatchet job in a case that really doesn't necessarily belong in federal court. Not to say there
Right.
aren't federal laws that weren't convicted, but who was the last state court politician in New York to be indicted federally for failure to properly disclose contributions or for straw donor transactions in a state election in violation of state election law.
Right. I mean, I don't know. Nobody's even coming to mind, right?
Yeah,
So
I suspect that there might be more members of the New York legislature who would be exposed than not
yeah,
if you
right,
really look close.
right. King, what were you going to say?
In my in the distant past, I've seen the feds take after state officials like this, but in general, the type of felonies that the state officials engaged in were a whole lot more persistent, ongoing, far spread, a whole lot more money,
Right.
and more at stake.
Well,
Uh,
and you get the feeling every time that the state is not going to prosecute it, right? There's no stomach to go after the person on
well,
the state level.
not only no stomach, but the state kind of a I'll look the other way. If
Right.
you look the other way, everybody understands it's going on. So let's keep it going. And somebody in the U.S. Attorney's office says this is wrong. I'm going to stop it.
And
And
the
they go
feds
on
are
a
the only people that can stop it. Right.
yeah, and they go on a crusade
Right.
against public corruption at the state level. This doesn't smell like that.
No, it doesn't. And that's why I was wondering, do we think they even gave New York a chance to pick it up? Steve thinks no, that they just did it anyway. Themselves, the feds. You guys agree with that?
I agree. Yeah.
Yeah. Okay, so let's turn to the substance of it. Do we think they can make out these charges? So you've got, there's all this discussion about he didn't make his financial disclosures, which is not illegal under federal law. And then you got a lot of discussion, and this must be the staffer that the media is reporting turned against him, right? They don't use this person's name in the indictment, of course. There's a lot of the staffer going back and forth with the Turks talking about the straw contributors. So, straw contributors, for anybody who doesn't know, is individuals can donate to campaigns, companies cannot, and there's limitations on how much individuals can donate. So sometimes what happens is somebody who has money wants to give more than what the limitations are. And I'm really simplifying this, okay, and boiling it down. And then what they do is they give money to other people who the contribution is made in the other person's name technically, but they're not actually the source of the money. So just like a straw man gun purchase, this is a straw man contribution to the campaign, and that is illegal under federal law. It's illegal under federal law for foreigners to contribute to our elections here, to campaigns. So they've charged him with both of those as freestanding charges. But there's a lot of facts, as you're saying, Ship, of this back and forth with the Turks. But with the staffer, there's not very many allegations, paragraph allegations, where Eric himself is interacting, doing the bad stuff. There's a couple of places. So, what do we think of this?
Well, I think the problem is that when you have just two or three instances of actual communications directly involving him, then the there are several allegations about about making efforts to sort of create dummy invoices and other kinds of false documentation.
But that's on the travel, not on the contributions,
Well,
right?
okay, so I understand that, but it's still sort of all part of the same scheme.
Well, that's where I was going to on the bribery. The last count, the bribery. They're saying, okay, Adams took these uh, uh, free trips or low cost trips from the Turks, from the airlines, and then they then contributed money to his campaign, and then he turned around and took more trips that are low cost or whatever, and they're saying that it's a quid pro quo, but it doesn't look like a quid pro quo to me, right? They allege at one point, well, that they were literally in exchange for one another. Like he took the trips, and in exchange for that, what he was giving the Turks is he caused the New York Fire Department to issue, I guess, like a sign off on the Turks consulate in New York, that they would be able, that the safety inspection was signed off on, even though it wasn't going to be signed off on, so that they could open the consulate when they wanted to. And the indictment says that those things are linked, but do we really think that that's right?
Well, there's a reference. I can't remember. Like it's in somewhere in the mid 20s
Mm-hmm.
in the page number. There's a reference to an exchange of information or communications where the Turk official says, basically we've supported him and now it's his turn to return the favor. And then the response is, I know. I can't remember whether that response comes from Adams or that response comes from the Adams, representative.
Yeah.
But that is a link of the largesse they had bestowed upon him for the return of the favor. To basically, they wanted to be able to open the consulate at the same time Erdogan, the Turkish president, was visiting New York.
Right. This is on
They,
page 33 over to 34. It's in paragraph 38, subparagraph G's and George. Go ahead, King.
yeah, but they also say throughout that every time they did a favor for Adams, they did it to quote gain influence
Right. To gain influence over him, they keep saying.
over him.
Yeah.
And period. They never say it's in exchange for an agreement to do something unlawful
Right.
or or to use his official office to give them some favor or monetary benefit, which is what you need to show with a bribe. Then it never says that.
Right. I agree. It looks more like a gratuity. The the travel benefits he's getting, and even the campaign contributions don't seem to be conditioned on, hey, you're going to help us out with this consulate. It's like, hey, we're your good friends who paid for your travel and we contributed to your campaign, and now you're in a position to do something for us, and so we're asking for a favor. And that's not probably tight enough for a bribery conviction, I don't think, as a defense lawyer. Ship, do you disagree?
Well, I think there's a lot of room for the defense to maneuver there. At the end of the day, it's going to be a conclusion, not an established fact. It's not subject to empirical proof. It's going to be, did at the time Adams was receiving these benefits, did Adams contemplate that he was going to have to produce for the Turks at some point in the future on the issue and a time of their choosing?
Right. Right, but that makes it seem like it's a very specific agreement, and I don't see a lot of facts supporting that. I mean, they can say that, but so okay. Um,
I would add that the transaction itself, the help he supposedly gave them
yeah,
in exchange for all these campaign contributions and discounted travel, uh, what was not the typical kind of public act that results in a bribery conviction.
right,
All he did was pick up the phone and tell the fire department, get your ass in gear and issue this. I'll call it a temporary certificate to allow them to open,
right,
subject to a complete inspection. They hadn't even done the inspection yet.
right.
So they were faced with a typical bureaucratic snafu.
Doesn't that seem like that's something the mayor of New York would do anyway,
He
right?
would do it for any of his uh, friends and neighbors and contributors. He'd do it for everybody.
Well, for any
Now,
foreign government
Yeah.
opening a consulate, don't we think
Yeah.
now,
it's not going to embarrass the government, the United States, by being like, well, your consulate's not done yet. So when your president comes here, you're going to have to meet someplace else.
And don't forget that that there are crooked bureaucrats who
Sure.
will hold up licensing and inspections and things
Oh,
like
hey, and
that.
you think they do that
Look,
in New York?
oh yeah, and they're looking for something on the side.
Right.
So it's that's the kind of transaction that mayors, presidents, any executive in public office gets involved in frequently
Right.
uh, on behalf of constituents.
And the travel starts in 2016. Well, it starts in 2015, but they agree that he disclosed that. But then they sort of inconsistently take the position that even though it was disclosed, that somehow it's not contributing to the agreement, which that doesn't make any sense, but okay.
No, the only reason they alleged the disclosure was he quit disclosing once he
Right.
took office in Brooklyn.
Right. But then
So,
later on when they total up like all the money that he took, that is the bad money. How's that still not bad money? Right? I mean, if it's part of the agreement that you're going to do things in return for it, it's still part of the tainted money. The fact that you disclosed it doesn't really change that. But okay.
I'm not sure though that if you go back that far that you would be able to fairly characterize it as taking money to do
Aha.
bad things. I think there's
That's where I
simply
was going with
this
that.
is
That's where I was
this
going
is
with that. They
this
say it
is
starts
how
in
you
2016.
right. This is how somebody with influence arranges to have the politician return their call.
Right.
Not that they necessarily promise to do something they shouldn't do. This is sort of the Bob McDonnell
Yep.
prosecution in Virginia,
Yep.
where where the Supreme Court said, look, it's not a crime for, the governor to take a gift and then arrange a meeting, between the gift giver and some state bureaucrat to deal with something that's within the state bureaucrat's, purview. Just arranging
Right.
the meeting.
Right.
Um,
Now this is a
now,
little worse than that, right? Because they're alleging
well,
anyway that he
but in
pressured the fire
2015,
department,
but in
but not in
2015 and
2016.
2016, exactly. All they're
Right.
doing is because they talk about in there. The Turks are talking about, he might be the president someday.
Right.
This isn't sort of this is him selling himself to the
Right.
gullible foreigners.
Right. Right. I'm thinking that's probably not going to happen now.
Yeah, I don't know that it would have happened.
Right. But
So
this whole
this
indictment
is just
reads this way to me. It's like
this is
it's
just
like
a
it doesn't match
typical
up. Yeah.
just a typical slick talking politician.
Yep.
This is a less talented Bill Clinton.
Right. Right. So this is what I'm saying. I'm not sure how they're going to show that it's a quid pro quo because the payments, the travel stuff starts real early, right? Long before he's even running for the 2021 election.
Yeah, but
So,
I think wrap the travel stuff into all. I mean, just at some point they'll charge a conspiracy, and all the travel stuff will come in as overt acts.
right.
The travel stuff is not supporting any individual counts at this point,
Right.
and but again, that goes to the whole the entirety of my objections to this, the evolution of the speaking indictment. 90% of the stuff in that indictment doesn't need to be in there. 90% of it is probably not going to be evidence at trial.
Right. It's not supporting the charge. Count one
Exactly.
is conspiracy to commit wire fraud, federal program bribery, and to receive campaign contributions by a foreign national. And the travel doesn't have jack shit to do with any of
Right. It
that.
just sort of establishes how the relationship gets started
Right.
and then how it evolves from what it started as. And
Right.
it's once again, I think it's a good example of, this something we've talked about here with regard to, special counsels, and that's, the Department of Justice criminalizing everything they don't like.
Right.
So they look at this and they don't like it. It looks bad. The mayor of New York shouldn't be doing this for, dubious Turkish officials, government and business people. And oh my God, it's a for-profit university. How can you ever tolerate a for-profit university?
Right.
Um, So they criminalize conduct at the edges of some of these statutes, and as we've talked about, the last 5 times, well, six now, after Fisher, the last 6 times the Department of Justice has gone to the Supreme Court on an expansive definition of public integrity kind of crimes, they've lost all
They
6 times.
lose. Yeah. Now, not which is not to say that the mayor of New York should be taking free travel from the Turks and not disclosing it. Clearly, that's a problem under New York state law, right?
Right.
So, and also if the matching fund, so the way it looks like, Steve, would you say it's 5-to-1 ratio on the matching? Is that right? Steve, Steve,
8 to 1.
8-to-1 on
Eight to
the
one.
matching?
Yes. Two hundred
Okay.
fifty dollars. $250 got you 2,000 in matching.
Okay, so they allege that he ended up with 10 million from the matching program from New York that was paired up with the contributions made by the Turks. So, if that's right and those contributions are illegal and he knew that they were, then yeah, he's defrauding the state of New York. They say that, but of course they can't charge him with that because they're not the state of New York. So, I don't understand why this matching program is in here either.
It's there for wire fraud, and that to me was the one count that really stood out as being easily provable based on the facts alleged that he had the signed certificates that certified that the campaign contributions he received were lawful
Right.
and they were not according to the
But
indictment.
they can do that with they can prove that without the matching program from New York State.
No, but the wire fraud comes in to you had to use telephone and email to trigger the money coming to you from the matching funds. So that's what makes it a wire fraud. You're using deception, using the uh, wires in interstate commerce.
Yeah, but I thought they were, I agree with you, but I thought they were saying the wire fraud was the, like the payments for the tickets and the contributions themselves. I'll have to look at the indictment again. When I read it, I didn't link up the matching fund to the wire fraud.
Well, if they didn't, they screwed up because
Yeah,
I think that's their strongest case.
right. Because I'm looking at this is under count one. I'm looking at the overt acts and they're listing all the travel stuff as overt acts, but I mean that's not taking them anywhere, I don't think. And they're doing the false disclosure statements, okay, and now it's down to travel. All right, so here's the wire fraud count itself. They're just listing they just basically parrot the statute, right? They don't explain how does it tie into the wire fraud. So that's something we'll keep an eye on, King. Maybe you're right. Maybe they're through in the matching program thinking that would help them with the wire fraud. But we'll see. Okay, well,
I'll
go
just
ahead.
add that is how you charge a wire fraud uh, count, as you allege that somebody you have used wires in interstate commerce to defraud somebody into giving you some money. And
Right.
matching, that's what happens when you get the matching funds. So if you deceived the state to release their matching funds based on false representations and other forms of deception, then there's a wire fraud count.
Right. And you may be right that that's what they've done because there is the necessity of having that fraud aspect for it to be wire fraud. I had a case years ago where the government was really, this should have been handled in New York, but it was a DC case. It was a securities fraud case, and they coupled it with mail and wire fraud. And their argument was that the wire fraud, was a fraud on the market. And I kept telling the district judge, that can't be. The mail fraud and the wire fraud are both property statutes. You have to be defrauding someone out of something. You can't be just defrauding the public generally. Like that's not how wire fraud works. Um, so you may be right, King. That's a good pickup. That really that's the only thing in this indictment where somebody's losing money.
Well, they had the federal program fraud charge.
Yeah, but they're
too.
charging that as bribery. They're
They're,
linking that to the bribery
and the conspiracy count, they list that as one of the
objectives of the conspiracy.
And so
Yeah.
the federal program fraud would tie into the wire fraud in terms of them saying that they're both fraudulent.
Yeah, but when you look at the bribery count, which is count 5, they're specifically tying that to the federal program fraud. And they're not. I don't think. Let me look back up at the wire fraud count. They're not specifically tying that language into the wire fraud, but they are to the bribery. So they're doing the best they can, right? Would we agree to make federal offenses out of this conduct in a situation where most of this conduct actually looks like state court violations? What do we think?
I'd say I wouldn't go that far. It's both state and federal,
Mm-hmm.
but it's the kind of conduct that the feds usually leave to the states, unless there's a real good reason not to.
Except for maybe the campaign contribution part. I could see them charging that if the politicians taking contributions from foreign nationals.
Yeah, but I think but for a state or local office,
Yeah.
it's almost one of those things. If you're in public integrity or a U.S. attorney's office, you just say, you guys police your own house.
Right.
That should be the attorney general's office or the Manhattan or
DA. Yep.
the DA's office. I mean, there's plenty of federal office holders that need to be policed, engaging in similar conduct. It just
Right.
the whole thing just strikes me as having an ulterior motive.
Right. It looks very political all the way around.
Well, it's like any number of other federal prosecutions. It depends on the prominence of the target.
Yeah.
Well, that's true. That's true. I mean, it's a New York mayor, and
Right.
he's a controversial figure. Had other prosecutors really had a clear crack at somebody like Ed Koch, they probably would have gone after him too.
Right. Right. New York is, one of our most important cities. Is what people always say. I'm not sure I've always agreed with that, but that's something you often hear. Well, okay. So Eric is so far has not resigned. I don't know whether he's planned to or not, but his criminal case will trundle along, whether he is mayor or not. And I guess we'll find out next week, sort of how the parties and the judge plan to go forward. As of now, there's no other dates, no motion dates, no trial dates, nothing like that yet. So let's shift over to P. Diddy, Sean Combs's case. Now, as Chip has said, this is indicted out of the same office, same U.S. attorney signed off on this indictment. Sean Combs, so from the music industry, shall we say? I'm sure everybody knows who P. Diddy is. They've charged him with RICO. And what I wanted to talk about here, you guys, is both the indictment and also the detention, because they detained him. The federal judge there detained him, a woman judge, I will say. And I wondered if that had something to do with it, given what the allegations are here. So I wanted to talk over the detention result. So, Ship, did you read this indictment too?
Yeah, and I wrote a pretty extensive Substack story on the details or lack thereof of that indictment and
Yes,
why I
exactly.
think why it is structured the way it is. I think.
Yeah, I didn't see your notice on Substack on this topic. I'm sorry, I must have missed that. Okay, so I get those and I look at them whenever I have time, but I must have missed this one. All right, so let me find that indictment. While I'm doing that, King, let's start with you. What did you make of this indictment?
It was a little surprising, and then I reread it, and they are treating whatever P. Diddy has going with his music business
Mm-hmm.
and his image. They make a big pitch. Part of it involves enhancing his image,
His
which
brand.
his
Yep.
brand, which brings in money and adds value. Uh,
Yeah, they say he has a
and
record label, a
yeah,
recording studio, an
so
apparel line, an alcohol spirits business, a marketing agency,
uh,
television network, and
yeah,
media company. Okay.
all of that
It's
involves
legal.
legal, legitimate, on the surface, legitimate business corporations, business operations, and a lot of people who help him run that. And this indictment says basically that entire organization is engaged in racketeering,
Right.
and it as if it were the mafia,
Right.
and it goes into great detail about the methods that P Diddy uses to keep his victims in line. You know, assault, physical and mental abuse, uh,
Kidnapping. Yep.
kidnapping, arson.
Yeah.
Uh,
Although
uh,
there's no facts that tell you what the arson
they
is.
don't. There's no facts about anything except for some one victim woman who was beaten up and threatened and kidnapped, or at least held
Detained.
against her will to
Yeah.
from leaving. Uh, so, but just to step back a minute, RICO, which is the Racketeer Influenced Corrupt Organization Act, uh, came into being, when was it? The late '60s, I want to say. Um,
Yeah. Steve says yes. Yep.
yeah, '68, I think, or so.
That's the year I
Uh,
was born. Woohoo! Good year.
and uh, that was the year
Little
I.
after that came, it was actually after Nixon took office. It was part of,
Oh, okay. After Nixon, then it'll be around '72.
no, it was during Nixon's first term. It was a Nixon initiative,
Yeah, Nixon's first term was 69
9 to 70.
through. Yeah, so it would have been what? So we're still in the '60s then.
Yep.
When
Late 60s. Yep.
okay, and my firm belief, 100% believe, that unlike other acronyms, the name Racketeer Influence Corrupt Organization Act did not come first. I think the name RICO came first.
Hmm.
You know why?
Well, I have a vague recollection of this. You telling us this before, but now I can't remember what it is. So go ahead.
I
Tell us.
say it comes from the main character in um, a 1932 movie starring Edward G. Robinson called Little Caesar.
Right.
And he played a character by the name of Rico, who worked his way up to the top of the mob by killing all of his rivals along the way. And then I'll give you the last line of the movie. Uh, as he's dying from some gunshot wounds that the cops shot at him, he says, "Mother of mercy, is this the end of Rico?" Uh, that's where that statute came from. The name of that statute came from, and they found words to fit Rico,
Hmm.
because it was designed to go after the mob.
Right.
And you think about it, step back with the vow of silence kept prosecutors from getting the higher ups in the organization. They would be able to put away the murderers and maybe drug dealers at the lower echelons of the mob, but they would keep their mouth shut, and they could never go up and get the higher ups who were really getting all the money and running things. And Rico came about to solve that problem by creating a crime that made it unlawful to work with an organization like that, to operate and associate with an organization
That
like the
uses crime in order to
right,
exist. Yeah.
to exist and raise money and keep everybody's lips so tight,
Zipped. Yeah.
uh, and 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 so by throwing that statute against Diddy, and this indictment reads like an underworld indictment. It reads like that's what P Diddy has going here, a mob like organization whose purpose is to commit all these crimes on an ongoing, continuous basis, year in and year out, with female victims who are sex trafficked and abused physically and mentally, and there's money involved. We need the money to buy the 1,000 bottles of lube, and that's sort of, it's the
Don't forget the
craziest
baby
thing.
oil.
Yeah.
Oh my goodness.
So
Okay,
that was my take.
so to compare and contrast these two indictments, all right, Eric Adams's indictment is 57 pages long. This indictment is 14 pages. There's hardly any facts in here by comparison when you look at these two suckers side by side. So I thought that was interesting. Um, and the the description of what the statute says the racketeering is carried out through an enterprise. And then the definition of enterprise under the statute, I just had it here and now I've lost it. I hate it when that happens. Um, is could be an individual, which is stupid. How could an individual be an enterprise? But this is the way Congress writes statutes. A partnership, corporation, association, or other legal entity, or any union or group of individuals associated in fact, although not a legal entity. So it doesn't have to be like an incorporated thing. It could just be a group of people. But the entity has to be engaging in racketeering activity. Um, but we've always applied this statute to kind of the mob type scenario, although wasn't it Giuliani that first made that connection? Um, where you have an organization whose purpose and business is crime. And here, P. Diddy's businesses are about the music industry, right? Not about criminal activity per se. The fact that he's maybe using some of his employees to engage in criminal activity is not great. And again, I'm reading through this and I'm like, there's loads and loads of state court criminal charges in here, but the feds have charged it as RICO. Ship, what's your
Yeah,
comment?
here's the angle that you're missing, and this is what's not in the indictment, but is widely trafficked rumors in the industry, and that is that Combs has used these parties and has used videotaped episodes as leverage against artists to work with his company, to work for below, standard compensation, to keep them in line under threat of exposing them, uh, all for the purpose of driving revenue to his companies.
So kind of a involuntary servitude extortion type of angle.
Exactly, exactly.
Right. Well, that
Yeah.
would make more sense.
There's lots of this all original. It didn't all originate. I mean, these rumors have been around for years, but there was a civil suit filed against him back in the
Which he
fall of
settled like the next
2023.
day.
The fall of 2023. Yeah, he settled quickly after this. The story behind it is that the woman who was a paramour of his for a period of years and had participated in a lot of these events, um, she came to him, or somebody on her behalf came to Combs and said she's going to write a book. But, if you pay her $30 million, she'll sign over all the rights to the book to you. So, catch and kill for $30 million. And, his representatives rebuffed her. So then they thought, well, rather than write a book, we'll just file a lawsuit that basically reads like a book.
Right.
And they filed that lawsuit, and he ended up settling it for $30 million. But there have been a lot of stories about these events over the years. Um, and those have circulated for a long time. And it just, I think that lawsuit put enough meat on the bones for an
Yeah.
enterprising U.S. attorney to say, let's dig into this a little bit. Let's use the powers of the grand jury to begin to let's get some of these details in this lawsuit under oath in grand jury, and let's start subpoenaing some records. Um,
It
I,
still strikes me, though, as a defense lawyer, that like they're saying the purpose of the enterprise is to operate the music business. I mean, how can that be? And then the
Well,
next one, as King points out, is preserving and protecting his reputation and his brand. I mean, we're a long way from the mob when you're talking about this.
well,
lem-
but I think
can I jump in?
Sure.
what
Yet even though Rico is targets the mob and mob like enterprises, there's nothing in the law that requires the enterprise itself to not have some legitimate business going on, and that was on purpose on Congress's part.
Right, because you don't want them hiding behind that successfully.
Well, yeah,
But
and the mob did,
yeah.
and they knew they did. Like pizza parlors
Hmm.
would be the front, and all the dirty money would get washed through the pizza parlor.
Yeah,
So
I understand, but like this one says, fulfilling the personal desires of Combs, particularly those related to his sexual gratification. I mean, can you just imagine a mob case with that? That this is the point of the illegal enterprise? I don't know.
well again though there's not been factual allegations put
Yeah.
forward. I think by design. There are long-standing rumors that he was the adult guardian of the rapper now who goes by the name 50 Cent, who,
Right.
very prominent.
Yeah.
Combs was his adult guardian when he was 15. There I don't know if it's Jay-Z or somebody else was the adult guardian or had custody of some fashion of Justin Bieber when Justin Bieber was 16.
Right.
And so there are a lot of angles here that are going to come back to
Well, they're going to have to
underage
amend this
sex with
indictment to add that.
underage minors. Oh,
They're gonna,
unless
because that's not in here.
that's why the indictment's written the way it is. The
Yeah.
indictment is written as basically a foundation for a guilty plea without those details coming out.
Yeah. Now it
And
says
and
through
the
the
and
exploitation of women and the use of commercial sex workers. So the way I read this is that they're seeing the women as victims, and the person, because they've charged him with this RICO and also with Mann Act violation. Mann Act is transporting someone across state lines for purposes of prostitution. So the way it reads, it seems like the women are the victims, and the people who were transported across state lines for purposes of prostitution were these male sex workers that who then participated in these sexual parties that Combs was enjoying and videotaping and so on and so forth. Is that the way you guys read it?
with a
uh,
lot of homosexuality mixed in. That's the dirty little secret here.
Right. It's only barely hinted at. Go ahead,
Yeah,
King.
but
yeah,
in the stories told in the press or in the industry, this is Combs is a well documented uh, bisexual,
Okay.
and a lot of the victims were actually young male rappers who then Combs used the compromising videos, and the sex workers were in many cases male sex
Right.
workers.
Right.
And
and
Combs used the compromising videos to sign these young male rappers to his record labels and keep them under control through leverage.
Okay.
except this indictment doesn't say that.
No, it doesn't.
The only victims it identifies are women,
Females. Right.
females who are either friends or artists who he wants to control. But there's something not in the indictment, but maybe touched on by it. Uh, if you get into look at the news articles lately, there's been a series of unexplained resignations of
Mhm.
high executives in the music industry lately. And the rumor, at least, is they are somehow mixed up in this as maybe participants, and i- if in the context of a RICO case, possibly the funders.
Mhm.
Where is the money coming
Or the
from?
beneficiaries at the other end of their
To
investment.
pay,
Yeah.
where's the money coming from, and who is benefiting from these artist contracts that P Diddy is uh, getting under control?
Yeah.
So the industry itself, or some parts of the industry itself, could be where the government goes next.
Well, it certainly is the case that the facts, such as they are in here, are very ugly, right? You're talking about physical abuse of victims and kidnapping and so forth. Arson is alleged. There's no facts that tell us what that is, but
There's a
that's
there's
a
a
kind of a
there's a
threat.
story. There's
Yeah.
a well-known story. It was a competitive record producer whose house was burned.
Right. Right. So, I mean, that looks like mob conduct, right? We're using threats, intimidation, threats of violence, examples of violence in order to get people to do what we want them to do. Okay, that makes sense. I really think, though, that they, and maybe you're right, Chip, maybe they just have put the bare minimum in here because they think he'll do a quick plea. But if that's the harm that you are going after as law enforcement here to say this is not an okay way to run the music industry, then why don't you just say so in your indictment? And
because because the security director for Combs has been cooperating. He
right,
has told them about the video system that was installed in Combs's three houses that are at issue, one in
right,
Los Angeles, one in Miami, one in somewhere in the Caribbean. And those tapes exist. And the feds don't necessarily have them all.
right.
I mean, if you're Combs, let's assume the worst case. If you're Combs and you are engaging this kind of activity and using these tapes as leverage for financial advantage, business advantage,
Hmm.
wouldn't you keep a few different copies in a few different
Oh,
locations?
yeah, for sure.
So I think the feds are going about this very gingerly for fear of those tapes basically surfacing, and then that's like a huge swath of Los Angeles music industry.
Right. Well, I think they've done it so gingerly that as a defense lawyer, I'm looking at it thinking, wow, are you sure you got enough in here to make out these charges you've charged? Because it's awfully thin. At a minimum, they're going to get a demand for a bill of particulars, right? From a
Oh,
good defense
no,
lawyer. Although maybe they're going to do a quick
Well,
plea to
so
get rid
but
of
now
it.
what else is missing in the indictment in terms of the RICO and the forfeiture allegations?
Well, I think that, I mean, they allege the elements, but there's almost no facts
There's
from
no
which
property
derive.
identified. They're
Right,
only
exactly.
seeking the indictment as it's written only seeking a money judgment,
Hmm.
which means they can negotiate that with Coombs. Basically, the properties. I mean, they could take the houses. Those
Right,
properties are clearly involved. That's where the parties took place. That's where the criminal conduct occurred.
right,
They could forfeit the houses. Everything else they would have to forfeit as proceeds. Okay, so they could back off that and say, you've got a family, you've got kids. We will not dispossess them of the riches that you acquired over your lifetime if you plead guilty and forfeit the
mhm,
houses.
Right.
this,
I'm not
Now,
sure how
I
that's
mean,
vindicating any victim, though, of these kinds of
well,
schemes
victims
of.
don't have the victims don't have a right to pursue forfeiture. The victims can sue him
No,
if
but
they
I'm
want. You know,
I'm
if the
talking
victims want to go
I'm
public
talking
and sue
about
him, they
justice,
can.
not money.
Well,
I'm
but
I'm
again,
not
though,
talking about money.
they are weighing the interests of look. They are weighing the interests of the celebrity culture in Los Angeles. You're not
Well,
talking
that's
about
true.
just rappers. You're talking about movie stars
Yeah.
and executives in movie studios and record companies. I mean, these Sean Diddy white parties
Hmm.
were the rage in the 2000s and 2000 teens. I mean, everybody went to them. You know, it wasn't Mariah Carey. Who was it? Christy Teigen, practically without realizing it, said in an interview that she and her husband had sex in the middle of the crowd at one of his parties.
Right. Okay.
The
Well,
Obamas attended one of his parties before he was president.
right. But I mean, your example of Justin Bieber, if young artists really are being coerced this way, it would seem like maybe we should be sending the message that we're putting a stop to that.
Well, I don't
How?
think it's going on. I don't think it's going on any longer. The Bieber thing was 10 years ago. Bieber's in his mid 20s now.
Right.
So, and if you look at that, read that closely, there's nothing listed in there after 2018. I don't think.
Right. No, there
yeah,
isn't.
can I add?
Sure.
Um, RICO cases are potentially extremely far-reaching, incorporating a large number of so-called predicate acts, which are the underlying crimes that are done by people associated with the enterprise. And those crimes are defined in the law, and they include both federal crimes and state crimes. It struck me that this particular indictment outlines a number of state crimes,
Yeah.
and every one of them is California.
Right. They are. I noticed that too. There were
Eh,
no Florida or New York
There
sites.
was and P Diddy doesn't live in New York. These parties were mostly out west. So why is this in New York?
Yeah. Right. Well, he owns a home in New York, I think, or was one of the companies maybe was incorporated there.
Yeah,
So,
his. Okay, so just if you understand the history of the rap business a little bit, Combs was New York based. There was the famous East Coast versus West Coast rap wars of the 90s and 2000s. Tupac Shakur gets murdered. He was a West Coast rapper, you know, under the tutelage of Suge Knight, who's now in prison. Who's the other guy? Notorious B.I.G. is was a Combs protege in New York. He gets murdered. Okay, so Combs has always been the East Coast guru.
right.
Yeah, he has houses everywhere, and I think most of this criminal activity happened in California. But his companies have all been headquartered in New York.
Right. So there's no problem with bringing the case in New York technically. But I did find it interesting that, King, you're right. Most of the predicate acts look like California conduct. So, so it's an interesting compare and contrast, though, I think, between these two cases, right? Where one is clearly the abuse of power. I'm talking about P. Diddy, right? The power over other people in a commercial sense. Um, and post the Me Too movement, we're holding more people to account for that kind of conduct. But to hold them account under the federal RICO statute, I think there has to be more. Now, Ship, you're saying there is more, and so presumably, that's going to get fleshed out, or as part of the plea, or maybe it's just going to be acknowledged that that's really what's going on behind the scenes, and we're papering it as best we can. So
Yeah. I suspect they're pushing for a plea,
a quick plea, yeah.
and I expect that we're going to see likely individual pleas from many other people that are linked factually in oblique ways to this whole thing, but without ever really laying out the true scope of the actual conspiracy and all the players.
And see, my question is that justice? I'm not sure that it is. Procedurally, this case is set, the next thing for a status, on October 9th. So we'll see what the judge thinks there. But let's turn just for a second to the detention issue. So, Ship, were you surprised that the judge in New York detained him?
No, because there's pretty substantial evidence over the last 6 to 8 months of him meeting with witnesses and attempting to pay them off to keep them silent. So you've got, I think he's detained as much on the basis of risk of obstruction as he is
Yeah,
on risk of flight.
I agree. And that's what I wanted to talk to you about because the Bail Reform Act, the judge has to make determinations about whether the person is a flight risk and whether they are a harm to a specific person or to the community. Part of the statute does say that either on the government's motion or the judge on her own can decide to hold a hearing if there are allegations of obstruction. But if there is obstructive conduct, that in and of itself, I never have thought was properly part of the detention determination. Ship, what do you think? I mean, they can charge him with obstruction.
Yeah, I think it actually folds in under the
Danger to the
uh,
community?
actually, I was going to say risk of flight. You know, the fact that you're attempting to prevent people from testifying against you if unsuccessful elevates the risk of flight.
Well, I mean, if he has to surrender his passport and be contained within his home and sell his airplane, I don't see how that makes it more likely he can flee the country
Those
because
are
he's
that
trying to intimidate witnesses.
that only mitigates a risk. It doesn't do away with it.
Yeah, but I don't like this. Well, he's interfering with our case, and therefore he should be detained. I do not see what that has to do with being a flight risk or being a danger. Now, certain kinds of witness intimidation absolutely could constitute dangerousness. Um, but I got the definite. I didn't obviously I didn't go to New York, and I didn't. There was no live testimony of this, but I followed a couple of people online who were in the hearing and were giving us a blow by blow description. I felt like the judge was offended at the treatment of women as alleged. And then the fact that he was talking to some of them and arguably trying to get them to get their stories straight. I just had the feeling that maybe she was more offended by that than she really thought that he was a flight risk.
I
No,
think
no,
that arson charge may have played some role. I don't know
Yeah.
because I wasn't at the hearing,
Yeah.
but
yeah,
I'm sure a judge would want to know about that. An arson to not to collect somebody's property insurance claim, but to shut somebody up or
Intimidate. Yeah.
uh,
yeah. I recall. I mean, I wasn't following it, closely as the events were unfolding. Actually, I think I was in court last week when it was happening. But as the bit that I read, I was struck by the fact that it seemed like the prosecutors put more meat on the bones in their comments
Yeah.
about what the specifics of the allegations having to do with the parties particularly, and the abuse of the girlfriend who sued him. All of her allegations are public record. They were all in a publicly filed federal court suit.
Right.
So they could talk about all of that, and they could say, that in one fashion or other we have corroborated, information that is consistent with the following, in a way of a proffer, in circumstances where, Diddy's lawyers are not necessarily going to want to stand up in court in a detention hearing and start arguing over it, particularly if they're likely to lose anyway. Um,
They
so
they made Herculean efforts, I thought, to get him released.
yeah, but that's in the terms of what they were willing and able to put up,
Yeah.
and not just him, but third parties on his behalf. That
But
was
not,
that was
yes, it was a huge amount of money.
yeah.
Um, but also with this selling the interest in apparently he owns an interest in a plane. Um,
Well,
you
he's
know,
owned several planes over the years. So
right.
it's like just you know. And again, that was something though that they knew this was coming because they've been making
Mhm.
efforts to sell this jet
Yes.
for a while.
Right. Yeah, exactly. Yeah. So, well, I haven't seen yet whether they're going to try to appeal that decision on the bond or release, or whether they're going to try to work something out first. It has the feel, doesn't it, of a case that's going to get worked out as opposed to Eric's case, which has more of a feel of going to trial. You guys agree with that?
Yeah, I mean, Combs is not in a great place.
Yeah.
The Brooklyn Metropolitan Detention Center has a fairly notorious record as a secure facility. Um, I think if it suddenly began to shape into, Combs is just going to burn everything down and dime everybody out who was involved, his time on this planet might not be that long.
He might be
Um,
happy to be where he is rather than out and about.
yeah, yeah. So he
Six of
might
one, half
be,
dozen of the other.
yeah, he might be, his motivation might be to get me out of MDC and get me to some BOP facility for 20 years. I'm still only
Right.
be in my 70s. I might survive.
Right. Yeah. Okay. So we will, keep an eye on these two as they go along, see what happens. But a little bit different fare for us. Normally most of our cases deal with politicians. Of course, Adams is a politician, but so let's turn for a second to Hunter. I only wanted to touch on that briefly, and then we'll talk about the former president's situation, which King has been writing very well about, interesting stuff over on Twitter. So Hunter's case, I would just want to mention briefly because he got a request, which it looked like the government went along with, to extend his sentencing in Delaware to December 12th. And then the California case is set for sentencing on December 16th. So that's the latest and greatest there. Abby Lowell is obviously planning to appeal both of those, I think, as we talked about last time. But what do we make of this? Just kind of get it all over with in the same week? Is that what we're doing?
Yeah, that would, I mean, then you'd have the surrender date would be the same to whatever one facility was sent to. If you stagger those too far apart, that creates difficulties. But um, so, I mean, it. I don't know when was the sentencing date supposed to be in the Delaware case.
I think at the end of October.
Yeah, I mean, I would just have to say, look, I push sentencing dates around all the time without
Yeah.
there really being any real significance to it. Sometimes it's just my calendar. Sometimes
Right.
the client wants to push it past a birthday or a holiday or an anniversary. And so, as long as you don't get crazy with your requests, moving a sentencing date is not that big a deal. And clearly, to have the two, you can't move the tax case up. So moving the
Right.
Delaware case back in line with the tax case, doesn't strike me as anything terribly significant or eventful.
Right. Yeah, I thought so too. It's kind of in the ordinary course. But I would want to go forward probably on the gun case first, also, as defense counsel. Um, and not the other way around. But, you've got two very different judges in those cases too. So hard to tell, maybe. Okay. So, King, have you got any comment on Hunter's sentencing dilemmas before we move to Donald Trump's cases?
No, except that he obviously wants to push it back as far as possible, but still within his father's term as
Right.
president.
Yes. And as a defense lawyer, you would rather have either your trial or your sentencing be just before Christmas, because people tend to be a little more open hearted then. Um, so, okay, let us then turn to the former president's case. I'm trying to find the docket here. So, King, I know you've been all over this. So, help us understand what has happened with Jack Smith's filing that we've been talking about for the last several weeks, where he wants to basically put on the record all the reasons why he thinks Donald Trump's actions, as alleged in the indictment here in DC, were personal rather than public or official, and therefore are not subject to immunity. And also, did you guys notice there was the defense did request a reconsideration on the dates, and Judge Chutkan denied that? Did you guys see that?
Yes.
Yeah. Okay. So
Well,
King set it up while
well,
I.
yeah, but she noted that there was no actual formal request for reconsideration. They just dropped a sentence into their opposition to the brief.
Right. Yes. They didn't file a separate motion. I was like, wait a minute, where was that on the docket? Did I miss it? No, I didn't. Okay, so King, set it up sort of where we are, what's happening now, and then we'll discuss. Meanwhile,
Okay.
I'm going to look for the docket.
Okay. We've discussed this before it took place and kind of predicted what Smith would try to do. He has now filed what I'll call his magnum opus, which he describes as 180 page, up to 180 page brief, which includes 30 pages of footnote references to an appendix.
Right.
So 150 page text talking about the substance of what Smith wants the judge to know. And then on top of that, 30 pages of footnotes to an appendix that's in addition to the 180. So, and the appendix consists of things like documents given to the grand jury, testimony given to the grand jury, interviews of witnesses, both recorded and memorialized in FBI 302s, and other miscellaneous pieces of evidence that he's going to stack up uh, in a pile. I have no idea how tall it'll be.
It'll be like when Reagan stacked up the tax code. It'll be like
Yeah,
6 feet tall.
and but right now we can't see it. The public can't see anything he's filed because it's all filed under seal, and she has given uh, the Trump team, until I forget the dates. It's like October, sometime in October. Ship, you know.
October 1st on the brief, October 10th on the exhibits.
Right.
Okay, those are the dates that Trump's team has to object to keeping it or having any part of it unsealed that is made public, uh, and objecting to Smith's proposed redactions. Smith has basically turned over the whole brief to Trump's team, but what he's filed in court is uh, a redacted. I guess the whole thing is sealed as it sits in court, but Smith proposes to make redactions in both the brief and the exhibits to protect, quote, sensitive matter, which would be the identities of all the witnesses,
Right.
uh, and their addresses and social security numbers and whatnot. But you get to see what they said. Uh, but we just can't tell you, the public, who it was that was doing the saying, uh, the testifying.
Their
And
motion says that their designated things are sensitive under the protective order, and Ship's going to talk to us a bit about that because it's very similar to, if not the same protective order. Ship, is this right that most of the J6 cases are working with?
I didn't compare them word for word, but it's actually the restrictions and definitions of sensitive material is very similar.
Right.
The J6 protective orders have highly sensitive, sensitive, and non-sensitive. So three classifications. So every time you get discovery, the government, which
Labels it.
yeah,
Yeah.
don't even get me started on why the government gets to label it first. That's a bone of contention I've had since day one. The government gets to label as highly sensitive, and then the defense has to fight uphill to convince the judge that label's wrong. Seems to me that maybe a special master might have been more useful to
Mm,
determine what, and then the two parties could argue against each other rather than give that privilege to the government. But that's a different subject for a different day.
but
right.
just to step back a minute and consider what Smith is trying to accomplish here. He he gets to he called grand jury witnesses throughout his investigation. The FBI interviewed probably hundreds of witnesses, if not thousands, and then piles and upon piles of documents that they've reviewed and asked the grand jury to consider, etc. Smith is going to go through all of that and pick the best, pick the things that he believes puts his case in the best light, and that is to show that is evidence that he believes tends to show that Trump was acting as a private citizen, a candidate, when he did everything that he's accused of doing when he violated the law in under the indictment. So he has cherry picked the witnesses, cherry picked the witness interviews, cherry picked the testimony of those witnesses, cherry picked the documents, and he's piled that up. And he's going to try to show as much of it to the public and to the judge as he can get away with. And then one sit back and smile
Right.
as all of the press gets their copy and writes about it every day, every single day between now and the election. And then his
Of
public
which there are
statement,
36,
yeah.
36 days.
And so and then as far as his legal posture, it will be, well, President Trump and his team get to rebut this, and they can file their what they think is wrong with all this, and put it on the record. And so, which filing you think the judge will take? you know, it that's a no brainer. And what I have been writing about is what that issue. What is that issue? Is the factual context in which Donald Trump did the things he did that are accused of being crimes and for which he has no immunity. And that context and those facts relating to what he did, who he did it with, what he said, and how it related to one, his campaign, or two, his job as president. Uh, those are facts that the Supreme Court told the judge to consider and take into account in deciding whether he was immune for as to all of it. Uh,
Or
and you
some of it, or some
or
of the
some of it,
charges,
or
or
some
some
of it,
of the facts, right?
yeah.
All of the above.
And
Yeah.
so by letting the prosecutor both cherry pick testimony that was taken in secret, that Trump had no right and no capacity to have a lawyer there, test the witness's memory, bring out things that show the bastard is lying, or show that he is making things up, or he's wrong on or he's selective in his memory. That's a big one. Uh, if you can show a witness is selectively remembering one thing when you look at the whole transaction, the whole context of what happened, you can come to a different conclusion. None of that happened when these people were interviewed by the FBI uh, or testified in the grand jury. Or if it did happen, Smith's not going to put the rest of it in. He's only going to put the part in that helps his case. So it is, in my view, a violation of Trump's Fifth and Sixth Amendment rights. It's a violation of due process and a violation of his right of confrontation of witnesses against him under the Sixth Amendment. So, because he was not given the right to challenge any of it at the time this happened. Uh, but and there's no way to cure it either. Once it gets into the public record, once it gets into the judge's mind, you can't unring the bell. It's he's hung.
Right. So are we all in agreement on this, that this way of proceeding is not either fair or probably constitutionally permissible, and that what should be happening instead is that Judge Chutkan should be holding a hearing at which the government, since it has the burden to overcome the presumption of immunity, attempts to do so by calling witnesses and presenting evidence, admissible evidence. Are we all in agreement on that point or not?
Yeah, and I actually think the way you could truncate it a little bit is, um, you could allow the presentation of direct by affidavit, and then
Mm-hmm.
only have those witnesses cross-examined.
By either party, that whatever
But
party didn't call them. Yeah.
exactly, but the party that proffers them just sets forth an affidavit that says the witness on direct would say the following things, and then you get the cross. That shortens it. But let me back up a little bit, because I was going through this earlier today. I'm actually writing a Substack. Just haven't finished it yet. I'll hopefully finish it tomorrow. There's more to this than the briefing schedule, particularly. When you kind of
Yeah.
go back and examine it, from a fairness standpoint as a practitioner. Let me fill in a couple of the gaps here. The decision came down July 1st. Now we'll just imagine that the light bulb didn't go on in the special counsel's head about how they were going to address the problems created for them by the decision. But at some point, somebody came up with this idea. Why don't we propose filing an opening brief and attach a bunch of our exhibits? Our exhibits will be grand jury testimony and documents that we required through grand jury subpoenas. And, where we don't have grand jury testimony, we'll attach, 302s of witness interviews and any documents provided to us by witnesses, blah, blah, blah. That's their grand scheme. Okay, well, they've had 88 days. They put on September 5th at the status conference, it was the special prosecutor who suggested September 25th or
Mm-hmm.
September 26th of the date, 21 days. So in effect, he was telling the court, we need 3 more weeks. We need 21 days. But they will have had
All
88
this
days
time. Right. Yep.
to put that document, to put that product together in a fashion, that makes them happy. The judge gave Trump 22 days to file a response.
Right.
Okay, so from the day Trump gets it,
Actually,
or got it on the
22 days.
22nd, what they got it on the 26th, and I think their response is due. I had the order up a little while ago, but I don't have it now. Their response is due, I think, on the 17th of October.
Right.
So they have 22 days. Now, back at the September 5th hearing, which I was in the courtroom. I listened to the whole proceedings. Nobody even suggested the difficulty of the redaction process under the protective order.
Right.
Okay. Now that thing reared its head in the motion to file an oversized brief. It's like, okay, we're going to file a 180-page opening brief, 4 times the limit allowed for by local rule. And we're going to file 4 volumes of documents. I haven't seen a page number given to the volumes of documents, but it's 4 volumes of documents as part of their appendix of exhibits. Now, they file it on the 26th. Later that same day, I believe, the judge issues an order on the redaction process. And she jams the redaction requirements the responsive redaction requirements on the Trump defense within the 22-day period. In other words, she'd given them 22 days in the scheduling order so that they could prepare a response. But now she just took a huge chunk of that away by tasking them with, you have to submit your objections to the proposed redactions, which the redactions proposed by the government will be minimal. You have to submit that. The first one is due 6 days after you got the brief, and the second one is due 16 days after you got the brief. The first one is on the brief itself, the second one is on the exhibits. Now,
Right.
can you get through a 180-page brief pretty quickly? Probably. It's 4 or 5 hours, sit down, just read it page by page, make notes about what you think shouldn't be seen by the public at this particular point in time. Fuck, if it was me, damn near every page would be black. I'd say, we'll argue over every friggin' line.
Right.
Okay, and maybe the same thing with every line of transcript in the exhibits would be redacted. But you might be talking about 1,000 pages there. But let's talk about why it's particularly unfair. One thing that special counsel did here, unusual in most cases, as I recall the Discovery productions back in the fall of last year, they produced the Jinx and Giglio material right away. They
Right.
did not hold it back. So all of
All
the
right.
grand jury
So,
testimony.
right.
Okay, so
Let me
so this
stop you
is
there.
go
So
ahead, and explain it.
some people don't know what Jinx and Giglio is.
All right.
So very, very truncated, boiled way down. Jenks and Giglio is information that the government has, statements usually, but other information possibly for Giglio, that deal with what the witnesses are going to say when they testify, and or problems or issues that the government's witnesses have. And that
And
kind of information.
prior testimony under oath, so we grand jury
Right.
transcripts as well.
Right. Right. Um, and so that kind of information is usually given to the defense at the end, just before the trial takes place, for reasons that are complicated and we don't have to discuss tonight. But it's unusual for the defense to get that kind of information this far in advance of trial, is the point that Ship is making.
So the special counsel's office gave that just as part of the general Discovery production in the fall of last year. So the Trump defense has had all of this material, but I can assure you that material runs thousands and thousands of pages.
Right.
Okay. Now, what's happened is, as King pointed out, the special counsel is going to cherry pick, given its vast access to this material as it was created. They're going to cherry pick exactly what they want and put those 4 binders. And the judge has given the Trump defense 22 days after they see the binders to comb through the tens of thousands of other pages of material that might contradict what's in the binders.
Right.
To create an
Or
alter.
to go out and talk to people and find additional witnesses, to get affidavits from them, or to
Or just
contact witnesses and say, well, you said this, but we think this document says they could be doing that privately, but you don't have time to do all that in 21 days. It's
yeah,
inadequate.
not when you only get it 3 weeks in, not when you
Right.
only know 3 weeks ahead of time what
Right.
you've got to confront and respond to. It is an impossible task, and it was impossible without the redaction dispute,
Right.
which is
Exactly.
now shoved in the middle.
Right. Exactly. King, what were
And,
you going
and
to say?
I was going to say, many of these witnesses are government friendly witnesses, and there's no obligation they have to talk to the defense.
Right.
So if you go to try to get the rest of the story from witness A, who's a government friendly witness, you have no way of getting it because he won't talk to you. He or
Right.
And
she.
yeah,
So
and let
that
me
doesn't
add.
take up any time. But what you
Yeah,
do as defense counsel is you go to other witnesses and say, well, this is what we got information was witness A said blah 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 blah, and you were part of that meeting. Is that really what happened? What are the countervailing factors? Is this other person operating under some kind of bias or other kind of problems? Like, you don't have time to do all of the due diligence that defense counsel have to do.
let me give you a more mundane problem. Let's say you get a hold of witness A, and witness A will talk to you, but witness A says, "Yeah, I'll talk to you, and I'll explain, maybe more information than you have." But I don't want to do it alone. I want my lawyer to be there. And
Right.
Leslie MacAdoo Gordon's my lawyer, and she's moving into a new house in Southern Virginia, and she's not available for a month.
For a month. Right. Yeah.
So what do you
Right.
do then?
Right. My lawyer just had a baby. My lawyer's
Yeah,
in trial. Blah, on and on and on. Yeah.
right. So nothing can get accomplished of substance in 22 days. This is it. Just and now I don't. There's nothing in the redaction order. So she issues an order about this redaction process she wants to take place. There's nothing in there that talks about how the disputed versions or the two competing versions of redactions will be settled upon by the judge and whether either side will be heard. For all the Trump defense knows, she may just issue an order one morning and the government's version of the redacted brief suddenly appears on the public docket.
Right. I know.
Now, this is why I've said in writing, I think I've said it here, Trump's defense, I don't know what they're doing. If it was me, maybe they're playing the calendar. I would be taking this to the appellate court and I would be litigating the justification of an interlocutory appeal on these issues, given that it's a novel issue of first impression, and I would get the jurisdiction out of the circuit, out of the district court.
Any way you could. And the
Any way you
judge,
could, even
based
if
on
you
her
lose
order.
it eventually.
Right. Exactly.
Any way you could have to include, in my view, to get the Court of Appeals' attention, the Fifth Amendment and Sixth Amendment issues, and perhaps some privilege issues
Hmm.
as well, because
Yeah, that's an interesting thing we don't know yet because we haven't seen the four binders.
Right.
Are there witnesses in those four binders where that witness was only allowed to testify because of a previous crime fraud exception being applied to attorney-client privilege?
Right.
That's subject to be relitigated. That was done for the purpose of the grand jury. It wasn't done for the purpose of the court.
If you look at Judge Chutkan's ruling on this question of reconsidering the schedule, which she takes them to task for not filing a separate motion on that. They keep raising it that the schedule is unfair. They're not wrong, but they are making the point, and she's not understanding them. They're making the point that King hit upon originally in our group, which is using this kind of information, grand jury information, documents that haven't been challenged, witnesses that have only been interviewed by the FBI, and we're just using the 302 statements. That type of evidence has not been subjected to the defense. And the government is just putting that forward as if these are established facts. They've made that argument to her, and she doesn't understand the argument. Her response to that is, well, in every motion, one side puts forward its evidence, and then the other side counters with its evidence or its arguments. But that's not what's happening in this situation, right? So she's missing the entire point that this is a Fifth and a Sixth Amendment problem. It appears to me she does not understand the argument. But also,
Either that, or and
yeah,
I'm leaning a little more in the cynical direction. Either that, or she understands that this entire case is actually doomed
right,
eventually to these
right,
problems.
yeah, right,
And so being unfair at this point and putting it out there is not actually a death blow. It is already dead. It just hasn't been pronounced dead yet.
right. But that's coming, right? Okay, so let's turn to the issue of whether Trump's lawyers are properly raising this Fifth and Sixth Amendment issue. They are raising it, but they're kind of not. They're not raising it as a separate motion. They're not really, I don't think, articulating it as strongly as I would. They didn't. We talked last week, King, about the research that you could do. Once you understand the issue, there are cases that help you with this. There are not very many, but there are some. But King, you think that maybe the defense lawyers are doing that on purpose, that they've decided to go another way?
I think they've decided against going the at least the Sixth Amendment route, which is complaining that they have they're being denied the right to cross-examine those witnesses, and you cannot use the secret
Uncross-examined
testimony.
testimony.
Right. You cannot use that because they weren't there to cross-examine the testimony. Uh, I think for some reason, they have decided not to go that route. Uh, Maybe the only reason I can think of would be that they do not want the judge to hold an evidentiary hearing.
Right. Steve and I were tossing this around today, so let's talk about this for a minute. Because in their papers, they complained to her that this point that we're making, that the government is putting this evidence in as if it's established facts. What they want to do instead, which Judge Chutkan does not like, is to say that you should decide first whether some of this conduct sort of divorced from the facts. But the idea of talking to state court officials when you're the sitting president, that is in and of itself immune, and that is immune as a matter of law, and she should make some rulings on stuff that's just simply immune no matter what the facts are first, and kind of narrow the issues down. They also continue to make the argument that they haven't even moved yet to assert immunity. And so, how is it that Jack Smith is plumping all this stuff on the public record here once we get the redactions straightened out, on an idea of immunity when they haven't even renewed that motion yet? So those are the things that they're arguing more strongly than this Fifth and Sixth Amendment confrontation problems. And Steve and I were tossing around, so I want to know what you guys think about this. It's similar to what you were just saying, Ship, about playing the calendar. Like, it seems to be like they don't want Judge Chutkan to make factual findings. Maybe they don't want her to hold a hearing at which she's then going to thereafter issue an order that says, I find the following things are established by the record. And then she spins out a bunch of facts that they're going to have trouble with and they're going to be stuck with in the Court of Appeals. What do we think is going on with this?
Yeah,
That's
when I
that
say
go ahead, Chip.
yeah, when I say play the calendar, I'm kind of thinking, a practitioner sitting down and saying, okay, so if we file a notice of appeal on X and such date, and we seek we ask, or I guess the first thing you do, they would file a motion for reconsideration, expect it's going to be denied, then ask for a stay on, from the district court, then immediately file a notice of appeal on the denial of motion consideration, ask for a stay from the appellate court. Even if the appellate court treats this on an expedited basis, they'd have the right to go to the Supreme Court. And so you sort of play the passage of time to
Right.
keep Chutkan in a box, not able to do anything without jurisdiction on the case, not able to release into the public docket that brief.
But they're clearly not being effective doing that if they're not even filing an actual motion for reconsideration. Making the
Well,
argument in
yeah,
response to a different motion isn't the same thing.
well, I think they've got right now until October 10th.
Right.
I think October 10th is the date that their objections or their redactions to the. So my point being, October 11th, by Chutkan's own order, is the earliest she could release anything to the public record.
Right. So maybe
So
they
between
wait until the 10th, you're saying. Okay.
exactly, wait till the 10th, and that now you're under 30 days to the election,
Well,
and
and
so
the
all you
election is really what we're talking about when we're saying playing the calendar, right? So,
exactly just
yeah.
just prevent the release of this cherry picked document into the public record where the press can run with it and no meaningful rebuttal is going to be possible until election day. So the later you do that, the more likely you're going to be able to eat up time in either the appeals court or making an effort on the shadow docket of the Supreme Court. Actually, we won't be on the shadow docket by then. We're in October, so the court will be sitting. To get Supreme Court intervention on a stay, telling district court, and because if you can get to that, if you could get something before Roberts, because he rides shotgun on the DC circuit, Then all of Roberts' criticism of the lower courts for acting in haste and not with due consideration of the meaningful questions before them all come back to haunt the special
Well,
counsel.
what's interesting is that Judge Chutkin could, if you filed that on the 10th, she could rule on all of it overnight and plunk that document on the public record anyway,
That's
right?
why I say
Without,
you've got. That's why I
yeah,
say you've got to do it on the 7th or the 8th, so you have a couple of days to try to get stays in place.
right. But playing the calendar also, I think, in this situation involves the election and whether Trump wins or loses the election. Because if they don't want her to make factual findings that they're going to be stuck with in front of the Court of Appeals, one way of looking at it is none of it really makes any difference if Trump wins the election, right? It
Exactly.
only is going to make a difference if he loses the election. But
Correct.
then I'm wondering, as a practitioner, if you have to look at the worst case scenario as the situation you have to deal with when you're a defense lawyer. So worst case scenario would be he loses the election, right? Judge Chutkin is going to make those factual findings whether you want her to or not, is what I think. So I don't understand this strategy of let's try to keep her from making factual findings.
I agree. I agree. I mean, my only, I would be looking for every opportunity and using every opportunity to
Right,
simply
you're right. You're trying to use the
throw sand
procedure
in the
to
gears.
prevent that. Yeah,
Right.
right. Yeah,
Throw
yeah,
sand in the
that's a
gears.
better strategy, I think. Yeah. King, go ahead. Your turn.
I agree with you. I don't see how you can, just in practical terms, what are they worried about? They're worried about uh, Pence testifying before the election
Right,
in live testimony. I'm not sure that's any worse than what he's already told the grand jury
right. Or in the
without
public at
cross
large.
examination.
Right.
I, I don't see how it could be worse.
Right. Right. I don't either. I don't see how you're going to get her to not make factual findings if you keep going down this procedural road. So let's assume, for the sake of the argument, that Chip's thing doesn't work out or they don't choose to go that way. And so I do not understand, as a defense lawyer, the idea of we're just going to kind of waive this Fifth and Sixth Amendment arguments because we're going to try to go for the, as a matter of law, it's all immune, and therefore, and we're playing the calendar, and therefore we're going to not raise these Fifth and Sixth Amendment arguments. I don't understand that at all. Do you guys understand it?
But, particularly since Justice Roberts, in his immunity decision, told the lower court to figure out a procedure that the court could follow to consider the quote context in which all this conduct by the president happened, and in that factual context decide whether it's within his official acts or outside his official acts and done as a candidate, etc. And basically told the judge, look at the facts. And I don't
Right.
know how you look at the facts without evidence.
Right. I don't know, understand that either. And she tells them that in her order. She's basically like, look, the remand directed me to take submissions from the parties and make factual determinations. And so that's what I'm trying to do. Now, I think she's doing it in a unconstitutional way and in an unfair way. Ship's point about the calendar is absolutely correct. So it's like wrong on a bunch of levels, but her trying to develop the factual record is not wrong. That's what the Supremes told her to do.
Yeah, I don't think a glorified proffer is establishing a factual record.
Right, I don't
Okay,
either.
it's not
It's
a
a place
proffer.
to start,
Yeah,
maybe, but yeah.
it's not a proffer in the extent that you actually include transcripts of what witnesses actually said. That's not technically a proffer. The 180-page brief is an effective proffer. That our witnesses are going to say the following things. Um, but that's not a factual record. That's again, that, like you said, that's just a place where you start to develop the record. That's and the actual record might turn out to be very different than the proffer. Well,
Right,
how
exactly.
can you make these decisions based on a proffer if at the end of the day the factual record is going to look very different than the proffer?
Right. And to King's point, you those witnesses said whatever they said in front of the grand jury. but they had no defense lawyer there poking holes in what they were saying. Their
Right.
testimony at a hearing in open court may look very different.
Well, and you don't have the context of their entire testimony either. You only have the snippets given to you by the special counsel.
Right.
And then it's like, well, let them, let the rule of completeness come into play. The defense can offer what they want. Well, yeah, but we didn't get a chance to ask them our own questions. That's how we would develop what we want.
Right. Right. So, yeah. So it's, I feel like the parties and the judge are struggling with, because they all seem to be talking past one another. But my instinct tells me that at the moment Smith is ahead on points, shall we say, in terms of driving this case in a bad direction, both legally and politically for Trump.
I'm not sure I agree legally. I think, as I've read back through the opinion, about what's supposed to happen and what the standards are, the last, the Supreme Court's opinion is set up as basically a test of legal impossibility for the special counsel.
Yes.
He cannot satisfy. He is
Right.
not going to be able to satisfy the conditions that the Supreme Court has laid down for establishing official conduct, but the presumption is rebutted.
Right. So let
That's
me say, I agree with you about the long term. I'm talking about in the short term. Right now, it feels to me like Smith he's driving the boat here.
well, but
Right.
the only things at issue in the short term is the
Right.
election. If the
Right.
outcome of the case is preordained by that opinion, if there's
Yeah.
no significant evidence that can survive that opinion, then the rest of it is all kabuki theater, just to have an influence on public opinion.
We are where King said we should have been from the beginning, which is once that opinion comes down, the case should be dismissed because there's just simply no way for the government to go forward on it.
Right. Yeah.
Right.
It's gonna end up, in the trial court level, the special counsel is going to get a very friendly disposition on the distinction between official and unofficial acts. The appeals court probably will not rubber stamp it the way they did last time. I think they learned their lesson. We're not going to follow down the same path as this district judge again, because we know that there's 5 votes sitting up there in the Supreme Court to basically slap us across the nose again and tell us we don't know what we're doing.
Right. Let me see if Steve knows the answer to this question. If they take that up on appeal again, will they get the same panel, do you think? As a related case?
Likely.
He says likely they will get the same panel. Maybe Henderson will do better this time.
Yeah,
We'll
but she might not be long for the court. So
yes, right. That's true. Okay, well, so I feel like the lawyering for Trump at this point is a little uneven, right? They are making some good arguments. They are saddled with a judge who's not receptive to anything they're saying, no matter what they say. So they can't be faulted for that. But at the same time, and I'm a little surprised because if you step back and look at how John Lauro and all those guys are handling his matters across all of the cases, I think they're doing a very good job. What do you guys think of that bigger picture?
well, yes, and okay. So the other thing I think we lost track of a little bit here is if you go back and look at the scheduling order that she entered on the 5th,
Yeah.
she scheduled several other things for them to do.
Yeah.
I mean, I mean, it's not like this is the only thing she put
No.
on their plate for the next 6 weeks.
Right.
And I think, I don't have any firsthand knowledge. I think they have a plan in place. I think they know what they want to do, and I suspect that they have discussed extensively the pros and cons of their various options, and they certainly have a lot more information than the 4 of us
Yeah.
do.
Of course, yeah. And they got to pick their spots. You cannot fight
Right,
everything in every
right.
case. It's impossible.
And I do know firsthand that there are more employers in there are more lawyers in the mix than just Lauro and
Of
Singer
course. Right.
and Todd Blanche I guess there's 4, several more. This is not a short-staffed effort at this point. They people working on multiple the documents that are underway are being worked on by 10 or more lawyers.
Well, that's why, and the judge knows that too. That's why she's not impressed with these arguments of, well, we've got all these other cases too. She
You
knows
know
there's
what
a
though?
team behind the team.
No, I understand that, but by
Yeah.
the same token, I think that's a horseshit response because these guys all have other clients and they have other cases, and just because it's important to her doesn't
Yeah.
mean that all of their other cases. I used that just the other day against a DC judge who's been a little bit of a pain in my practice.
Patootie.
No, I didn't say that. I said a pain in my practice.
No, I said it. Yeah,
And
you
I
no.
noted that the judge's demands on my calendar created ineffective assistance problems for other clients.
Right.
So how could the judge justify making those demands on my calendar when they were adversely impacting cases before other judges that the judge knew nothing about?
Right.
And that got a little attention. That got there. I could see a look of recognition. And so I don't care how many lawyers Trump can pay for. It's not like those guys only have one client.
Right, exactly. But the
And
judges
no,
have to
a
decide that,
district judge,
even not in a big case like this. They're like,
right,
well, you have to remind them, Judge, this is not my only client.
right. And Trump is under no obligation to continue to spend his fortune and hire as many lawyers as he needs to meet her timing demands.
Right. Right. So, what do we expect then realistically? What should people expect? Their defense, they may go down your road, Ship, of trying to get this in front of the Court of Appeals at how unfair the whole procedure is to them. I wouldn't hold out long odds of that, but you're right, and they may be able to slow the case down for a while. But do you think the public will see any unredacted form of that thing from Smith before the election?
I think some version of it's likely to be leaked.
Leaked.
Yeah. I can't imagine them leaving themselves open to simply a unannounced minute order saying that the
Here you
judge's
go,
version
world.
that the
Right.
judge's version that the judge's redacted version is now available on the public docket, because that's if they don't take a step to prevent that based on the schedule. There's no way they're going to know when that happens. They might just wake up one morning and there it is.
Right. And it happened overnight. Right.
Yeah, they happened overnight. And oh, by the way, the New York Times is calling, wanting a comment because they've had 20 reporters reading it all night.
Right. Right.
So I expect to see something happen by the end of this week. I think probably what I would be doing is, now that I have possession of that brief and I have possession of those binders, I would probably file a redacted version of the brief because that's relatively simple. It's 108 pages long. You can, two people can work through that in under a day.
Right.
And basically the default is when in doubt, redact. And so you sent just a heavily redacted version of that brief. But then before the 10th arrives, where you have to provide, your objections to the exhibit binders, which again, we don't know how many hundreds of pages or more that is. That's when I would step in and say, this is fundamentally
right. This
fundamentally
cannot be
unfair
done
process
effectively. Right.
to allow this particular filing to be released to the public in any fashion.
I am astonished that the government is even proposing to put on the public record anything from the grand jury or the 302s. Normally, they just howl if you even attach those to ordinary motions.
Right, and what's really interesting is, and they acknowledge it in their paperwork, and I haven't read it to see, it's kind of on the list of things I want to try to do. They acknowledge that this is a reversal of their position in Florida,
right.
where they sought to prevent the defense from putting any grand jury testimony or summaries of grand jury testimony in a public filing. They only wanted that information under seal. I don't know. I know they've offered a rationalization for why the reversal is, it was warranted.
Somehow makes sense, right?
Right.
Yeah.
But
What were you
what?
going to say?
Yeah, I had a question on the grand jury stuff. Uh, have they even met any kind of a burden that they might have under Rule 6E concerning grand jury secrecy? Don't they
No,
have to,
there's a provision that allows the judge to basically release whatever the judge wants to release. There's no
for
real
any
standard.
reason? For any reason?
Yeah.
In the interest
Can
of
you look that
justice.
up, Lisa, or can you look that up, Leslie? I mean, it's
Yeah.
like one sentence. It's almost meaningless. The
Right.
barrier to the judge.
Yeah, I'm looking for it here.
Because you got to remember, a rule is not a statute. A rule is just a self-imposed rule that the courts have imposed upon themselves.
All right, let's see. I'm looking blah 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 da 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 secrecy blah 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 blah.
I mean, it's not far from where it's in the public interest. It's
Right,
pretty damn
exactly.
close to that.
That's what I remember it being too. Yeah, the language. Dun, 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 dun.
Or for use in a judicial proceeding. I think that's it's like, yeah, well, I'm using it here in a judicial proceeding, so we're going to make it all public.
Right, preliminary to or in connection with a judicial proceeding is the first court
Yeah,
authorized.
like that's about as big a loophole as you need to drive a truck full of documents through.
Right. Yeah. Yeah, I think that's where it would fit under. So, let's see. Da, da, da. Yeah. So, well, okay. I will have to just see how this plays out. It's unlike any case I've ever seen. It's just, and the fact that the judge is just blithely going along or blithely going along, being like, well, this is just like the way we always do things. This case
Uh,
is not at all like the
yeah.
way we always do things. What are you talking about?
What do you mean electoral calendar? There's an
Right.
election?
Right. Right.
I'm
She
not even
says,
paying. I'm not even paying attention.
right. She says that again in this order that, the defense keeps raising that that's part of their, argument for things. And she thinks that's irrelevant. I just continue to be astonished by
Well,
that.
as does the special counsel. They think it's irrelevant too.
Right.
They
Well, of
just
course.
happen to want. They just happen to want to propose all dates that come ahead of the election.
Right.
Just
Yeah.
just
Magically.
just like they said they could try this case 5 months after the indictment was returned.
I mean, looking back, how fucking laughable is that?
I said it was time.
Yeah. Right. I know. I mean, but anyone who's tried any case at all whatsoever knew that that was nonsense. Right? This is not a, you know, uh, I had a case years ago where we resolved it they dismissed it. This kid had stolen one CD from the record store, right? Shoplifting one CD. this, you could try that case in an hour. But that's not this case. Good grief.
Yeah, you remember all the controversy about? Remember they raised the issue. Well, there's been 11 million page of discovery, and I don't know if it
Yeah.
was the judge going. So yeah, but now you have all these electronic search
Tools. Oh,
tools. You don't
tools.
have to
Yeah.
actually read that discovery. You just search for terms, and then you
Yeah.
go immediately to the important stuff, and you can ignore everything else. It's like, no, it doesn't. It doesn't work
It
like
doesn't work
that.
that way. That is ineffective assistance of counsel if
Yeah,
that's the way your lawyer's handling it.
yeah. Let civil practitioners live in their own little world. That's where they do that
Yeah,
kind of stuff.
exactly. And and what is the judge gonna just, like breeze her way through all these exhibits? It'll take a while to read all of that stuff, right? So, yeah, it's always been interesting to me that judges think, "Oh, it takes no time to do stuff." And then when they have to read stuff, actually read stuff, "Oh, it takes them fucking forever." And they're like, "Well, this is very voluminous." Okay, sure. Oh,
Yeah. Now it's
frustrating.
interesting though. I guess what's not clear in the whole redaction litigation is okay. So Smith has provided what he proposes a redaction version, and
Right.
then the Trump defense is going to provide what they propose as a redacted version to go on the public record. They'll probably object as just blanketly, but also then provide some heavily redacted versions. What's the process for resolving the dispute? Is there going to be a briefing as to
I know.
why
She doesn't
certain
say.
material should not be Is that briefing supposed to come along with the proposed redaction? Is that one more thing the Trump team has to do, is to justify their more expensive redactions on a page by page basis?
Oh, line by line, we got to go, go through. And, that kind of a hearing takes hours and hours and hours.
Right.
The other thing is, we haven't even got to yet the point of, okay, they have their own filing. Presumably, they're going to have to file that under seal also, right? And go through this whole thing again with whatever it is the defense wants to do. And then the government's going to reply. I
Right.
mean,
Right.
it's
Yeah.
just like a never ending procedure when this isn't really the way to handle this in the first place.
Yes. So, you know, Trump could put in like 20,000 pages of grand jury
Right.
transcripts
Exactly.
that
You
are
guys
all
read all
just
of this shit.
redacted.
Right. Yeah, exactly. Right. I'd be tempted to do that if I were them. I'd be like,
I was going to
oh,
say
what?
that if I'm not going to the Court of Appeals on a constitutional issue,
Yeah.
and I don't want to have an evidentiary hearing, that's
That's
exactly what I
exactly
would
what you
do.
would do. Yeah,
I
exactly.
would take every page of grand jury testimony and put it in as rebuttal,
Right.
and
Here you go,
and
And,
Tanya. You read
affi-
it
and
all.
affidavit on affidavit and redact
Right.
all of it, and then say, okay, let's have a hearing on what gets unredacted. And we got to do it line by line.
Make the judge read it all. That would
we
be
got to
that
make
would
we
be
got
good.
to we got to make a record. We got to make a record of the
Yes.
judge's decision.
Right. I mean, it's just absurd. The whole thing is absurd. Okay, so let's get to the final point here, which is if we look at what the Supremes told her to do, which the judge is not wrong that they didn't give her a lot of procedural guidance. I think they sort of figured she would know what to do, right? And they didn't spend any time themselves figuring out, how would we do that if we were doing it, right? So, okay, but the the defense's argument that some of these things should just be as a matter of law, these are immune because these are official acts. How do you guys think that squares up with the Supreme Court's directive to develop the factual record?
Well, yeah, I mean, if you look back, the court says what the court says is the first thing that the district court's got to do is decide which are official acts, which are unofficial acts.
Right.
So, that almost should just be a line by line analysis. Okay, is there anything in here that both sides agree is purely unofficial? We can cut it out and set it aside. Because for every official act, okay, so now the rest is disputed official acts. The Trump team is going to claim they're official, and the other side is going to claim they're unofficial. Um, so then the second line of analysis is, okay, where does the special counsel win? What is unofficial?
Right.
And the Trump team loses. We'll cut those out and set those aside. Now that's two levels of analysis done. So now we're down to what both sides agree are official acts, but the dispute is whether the presumption can be rebutted.
Right. By the government. Right.
That they're subject to immunity, and that's the test that that's the impossible test for Smith to satisfy.
Right.
There's no risk of intrusion upon the operations of the executive. No
Right.
risk, as
Now,
in
that is
not
the
minimal risk or tolerable risk, but
right.
no
None.
risk.
No. Right. That is basically what the Trump defense lawyers keep outlining for her that they want her to do. And she keeps coming in response to that by saying she doesn't really understand how they can do that without knowing what all the facts are first. So you guys proffer all your facts up, and then I'll decide whether something is immune as a matter of law.
Yeah, well, I mean, I think we beat this horse pretty much to death, but I don't think that proffering your facts is the factual inquiry that the court is talking about.
The Supreme's told her to do. Right,
Right.
exactly. So, but narrowing it down to just the issue of, do we think that there are things that are immune sort of as a matter of law on their face? And if there are, then why didn't the Supreme Court already say so?
Well, they did in effect, and I've looked through this language. I have not poured through it though, but the Supreme Court does say in one point that at this point they do not decide that the official acts subject to, okay, so the core official acts, the core that narrow subset, those are off the table. Like
Right.
managed DOJ. The court said that's off the table. Now, the court says there's other official conduct here that, upon further examination, we might say is off the
Right.
table, but we're not
Right.
prepared to say it right now.
Okay, so
You
let me
have
stop
to
you there.
develop a
You have to develop the record. Okay. That's what the way I understood the opinion also. But now Trump's lawyers are saying there are things that are sort of in the first category. They are so obviously immune, so obviously official acts and therefore immune, like talking to the DOJ is. The Supreme Court pretty much already ruled on that. So the defense lawyers are saying there are other things that are of a similar character, and therefore we don't need this factual development from Jack Smith, because you, Judge Chutkin, should just rule that doing XYZ is obviously official and therefore obviously immune. But I'm not grasping how are they making that argument in light of the
Yeah,
fact that the Supreme Court didn't say so.
exactly. And I would point out, if I was Jack Smith, I would say, look, the Supreme Court didn't have any trouble finding. The Supreme Court
Yes.
went through the allegations of the indictment in its summary pretty extensively, A to Z, and they clearly identified the DOJ stuff as being beyond our ability to litigate. Had there been something else of similar fashion, the Supreme Court certainly would have recognized that as well.
Right.
I think what the Supreme Court left for the court is the qualified immunity, or the presidential immunity not subject to rebuttal.
Right.
So the question is, can Smith pass the test to use some some presidentially immune conduct? Can Smith overcome that hurdle? I think that's where the entire fight is,
I do
because
too. And so I don't understand why Trump's lawyers they keep
I
trying
don't
to
either.
tell Judge Chutkin there's other things that are immune as a matter of law.
Yeah,
And I'm not surprised that she doesn't agree with that.
yeah, I think they're just trying to build in one more level of analysis before resorting to the evidence.
Right.
Now, maybe that's what they intend to take the appellate court on, the basis that that's a legal question.
Yeah.
That she is failing to resolve a legal question, or by implication, she is resolving a legal question against them, and that is the subject of an interlocutory appeal.
Right. Possibly. I just would worry, if I were his lawyers, that the answer to that in the appellate courts is the Supreme Court basically already decided that. And so what are you doing here? You should be
Yeah,
down in the district court developing the factual record.
yeah. And then the question is, how many days does that take?
Right. Well, yeah, as a strategy matter, you might pursue that course. King, your thoughts on this?
It's hard to have a thought without knowing what the Trump strategy really is,
Yeah.
because they may surprise us. We don't know.
Right.
They may have thought of something we haven't thought.
Sure, for sure.
They're good lawyers.
Yeah.
I cannot say they're making the wrong decision without hearing what that decision is.
Right. Well, I'm prepared to say that I think it's the wrong decision not to preserve that Sixth Amendment argument. But, you may be right that they have a strategy on this other point about saying things are immune as a matter of law, as opposed to they need to be factually developed. And I wouldn't blame them for being afraid of any kind of factual development from this particular judge. I just think they're going to be stuck with that no matter what they do, unless they run out of time. So,
I know another thing they're working on, because I got an inquiry and I provided what I do, is they are also, in the same time frame that they're doing all this other stuff, they are working on a 1512 motion to dismiss as well, based on
right, of
Fisher.
course. Yeah, right. That was one of the other things she scheduled, was this question of what's left of the indictment separate from the immunity based on Fisher.
Right.
Yeah. That's another naughty problem, which is why, she shouldn't be pressing the pace, because these are not like run of the mill suppression motions that you litigate day in and day out. These are complicated constitutional questions. So, all right. Well, anything you guys want to say to wrap up? We've been going for 2 hours and 17 minutes by my clock here. So we're
No,
going to
I need
obviously.
to. yeah,
keep the
I need to roll things up or wrap things up myself anyway. So
yeah. We're going to keep an eye on all four of these things, obviously, and touch on
oh,
them
can
as they
can
come up.
okay, so I don't know. Well, how many people we got here? Several hundred, and whoever listens to this. I want to just talk briefly about what happened on my case last week, and I've
Oh
got this
yeah,
issue
sure.
coming
Go
up
ahead.
again.
Yep.
So this
So
is
Skip
so
got
because there's a
a
lot of
good result
curiosity.
on his
There's a
J6 cases. Yep.
there's a lot of curiosity about commentary that is beginning to flow out that the government, in an effort to try to salvage the 3 to 5 year sentences that it was getting for the 1512 convictions, where it's losing those counts either at prior to trial or on sentencing. How is the government going to try to hold on to those to sentences of that length when it has to fall back on a less serious felony violation of Section 231, which is civil disorder, carries only a 5 year mandatory, or a 5 year maximum sentence, and a much different guideline calculation. So I had one of the first cases where I think this came up, where it was squarely presented last week. Tyler Etheridge had gone through what's called a stipulated bench trial. It's really just a form of a guilty plea where basically you admit the facts and you admit that the facts satisfy the elements of the crimes with which you're charged. You're just not asked to plead guilty. But by all intents and purposes, that's the outcome of the case, is that you have essentially just conceded everything to the government that the government needs to get a guilty verdict. So uh, initially, the guideline calculation under 1512, which was one of the counts of conviction, the guideline calculation was 57 to 71 months. And that was when the 1512 offense had the sentencing enhancements that were later done away with by circuit court opinion. And the government asked for 60 months, so 5 years. And the defendant was at the first barrier when the barrier was breached, and the female officer was injured pretty badly when she was knocked over backward and hit her head on the concrete steps. She wasn't wearing a helmet. Suffered a pretty severe concussion. Was off work for several months. So not a great episode, but Etheridge, my client, was not at the forefront of that. He was about 6 people deep in the crowd, played no role in those barriers being knocked over and pushed into the officer and knocking her down. You kind of came along with the crowd after that and did, reposition some of those barriers, drug them out of the way, and freed the space for the, much larger crowd still behind him and the others to come forward and go through. After that, he doesn't do much of anything else other than, hang around and go places where, he shouldn't have gone. So we end up coming to sentencing, and the judge. This is sentencing been put off now for about 6 8 months while the Fisher case worked itself out, and the judge asked for a recalculation of the guidelines without the 1512 count, and this was before the Fisher was actually decided. But the judge just wanted to know what will this sentencing calculation look like without the 1512 count, since the 1512 count was essentially driving the calculation. So the way the probation officer calculated, the way the government grabbed onto it, it was going to be 18 to 24 months. The government then, wanted to use a couple of provisions of the guidelines that talk about, where a case is what we refer to as outside the heartland. And what some of the judges have commented on, not technically or not specifically in the context of sentencing yet, but in other contexts was, well, you have the uniqueness of the event, the uniqueness of the riot on January 6th, and the threat to interfere with the democratic process and upset the peaceful transfer of power, and all of this stuff that we've heard so many times. And that is something that's not adequately taken into consideration just by the basic civil disorder statute, which could be any kind of civil disorder anywhere without any involvement or interference with the peaceful transfer of power or just threat to democracy. So the government is using that rationalization now to say, so the 18 to 24 months, that could apply to any civil disorder anywhere in the country on any other government day. So that's not really an appropriate sentence for January 6th civil disorder. This should be a unique sentence because it's a unique event. So they came back after acknowledging that the guideline calculation was lower, 18 to 24 months, which I didn't agree with. I'll get to that in a second. And they wanted 53 months. So they, with Fisher being kicked out, for the government, the complication or the consequence of losing the 15-12 count was 7 months to them. Rather than 60, they were now asking for 53.
Right? Seriously? Yeah.
And
Okay.
they had a rationalization for it, which
They
I will
always
admit
do.
to. Once I got halfway through the rationalization, I quit reading it because it was just stupid.
Right.
So I couldn't even repeat it if I had to, if I'd been asked to. So then, so I had a different calculation of the guidelines. I disagreed on a couple of. Okay, so the calculation difference was I didn't think that there was physical contact, which was a 3-level enhancement. So okay, so we're talking a little bit of sentencing ease here. There's a base offense level of 10. It can go up 3 levels if there's physical contact. I argued against it. The judge disagreed with me, agreed with the government, gave the 3 levels. Then there's a question of, did my client adequately accept responsibility? The government didn't want to give him acceptance. I argued he was entitled to it. The judge agreed with me. So we got it down to from 13 to 11. Then I argued that my client was entitled to this new reduction for being a 0-point offender, meaning he had no criminal history, and this was his first offense of any kind. And while that puts him in criminal history category 1, the true 0-point offender, meaning first-time offense of anything, gets a 2-level reduction now, in addition to being criminal history category 1. So we went from level 11 to a level 9, and that's what the judge said was the guide. I'd actually argued 6 because I wanted no 3-level enhancement for physical contact. So I had it at 6. Judge came in at 9. That range was 8 to 14 months. So the government was at 18 to 24, but wanted 53. I was at 8 to 14. The judge agreed with me. Well, actually, I wanted 0 to 6, but the judge came down to 8 to 14. So I asked for 4 months. Actually, I asked for 8 months of home detention out of 2 years probation because he was in zone B of the table, which means he was probation eligible. The judge had the discretion to give him probation, as long as certain conditions were attached to that. And one of the conditions would have been 8 months of home detention, which was the lower end. The government wanted 53. And an argument I made that I thought, I'd been sitting on and waiting to make it the first time was, for 2.5 years in looking at government sentencing statements, the government has argued over and over again that, the guideline ranges are presumptively reasonable and the judges should not depart below the guideline ranges because the guideline ranges were high while they were getting everything they wanted.
Now they're not presumptively reasonable, Ship, because
Yeah,
they're too low.
exactly. That was exactly. And so I mentioned that. And I had a particularly, I don't want to talk about names, but I had a judge that I was confident in. And I said, and that's what I started with. For 2.5 years, I've read dozens of sentencing statements filed by the government. I'm sure the court has as well. One of the first points the government makes is how the guideline range is presumptively reasonable and should be followed. Well, the guideline range is 8 to 14 months, and the government's asking for 53.
Right.
So I ended up, at the end of the day, I didn't get exactly what I wanted, but the sentence was 7 months of custody and 7 months of home detention. So he gave him 14 months, but he only gave him 7 months in custody. He'll probably do 4 to 5 months before he's eligible for early release for halfway house. This is a father of 2 girls, one's 6 and one's 4, and he's going to be separated from them for 4 months.
Instead of 5 years.
Instead of 53 months, right?
Right.
So, as I have said many times, I'm going to have this same argument next week. I got a similar case next week where the government's making the same pitch. Don't have quite the same judicial. Not terrible, but we'll see. It probably won't come out quite as well. And the defendant is not defendant's got a few more issues in their background that I got to confront. But this is where the fight is now going to be. The government trying to hold up these longer sentences on the basis that January 6th was such a unique event that the guidelines can't be trusted, and we've got to have unique upward variances from the guidelines for the sentences to be properly reflect the seriousness of the crimes.
And how convenient that they think that sentence should be what the sentence was under the
Yeah,
statute that the Supreme Court said didn't apply.
I got another argument for that. I'm saving for a different court. I didn't think I was going to need it where I was last week, and I didn't. I have a better. I have a little more caustic response
Right.
on that proposition. That isn't it odd that we're arguing for sentences that were only the product of government errors in its charging and judicial errors in the sentence calculations. But
right.
Oh well.
But you're still saying that's the right answer. Newsflash.
Yeah, exactly.
No, it isn't.
Yeah. So I've got that one. That's I'm saving that for a different audience.
Yeah. Right. Yeah. You got to argue one way to one guy and a different way to a different gal because what works. Yeah.
So I leave tomorrow night, overnight flight. I have hearings on Tuesday, Wednesday, Thursday, back home, Friday, Saturday, Sunday, back out again on Tuesday of next week on an overnight flight for a 2-day trial at the end of the week on Thursday and Friday. And then maybe back home again. So it is suddenly the judges decided about 6 weeks ago that everything needed to be jammed into September and October. I don't know why. Because we know that none of them pay attention to the electoral calendar.
Right, of course not. Right. Oh, well, it's all just totally the rule of law. So why would you even question that?
Yeah. Didn't have any problem with defendants sitting in custody for a year while the government kept coming back and saying, well, we don't quite have the discovery.
We just don't have our discovery together, even though we didn't even have to indict these people or charge these people without our discovery ready, but we did anyway.
And oddly enough, I cannot identify a defendant who's been charged in the last 8 months who's been detained.
Yeah. Isn't that something?
All those cases that were automatic detentions, 3.5 years ago, suddenly the same exact facts don't produce any detentions anymore.
You think that's they've changed their tune? The judges have changed their tune, or is it the absence of 1512, or what?
I think to some degree the government's not asking for it anymore.
Yeah. Okay. Well, eventually we're going to come to the end of that string. So we'll see. And, it'll be interesting to see if there is a change in administration, what, if anything, is done with those cases, both the old ones and the existing ones.
Then it's my turn to retire.
Yeah, right. And sail off into the sunset. Then we'll all be retired except for Steve. He'll be the only working lawyer. We'll just have to ask him all the questions. You know how talkative he is.
That's why I'm still practicing.
That's why he's still practicing. Okay. All right. Well, I think enough for tonight. King, have you got any final words for us?
I have a word, but I'm going to save it until the dust is more settled on this Sixth Amendment issue.
Yeah.
But I'm going to save it. Just remind me, it involves the history of the Sixth Amendment.
Okay.
Going all the way back to Old England.
Old England. All right. Damn. We'll learn something for sure. Okay. Well, then we should sign off with your quote from tonight. Is this the end of Rico?
Mother of mercy, is this the end of Rico?
I'm thinking the answer is no, at least not in New York. All right. Good night, guys.
I got to head out till I see you next
Good night.
Good night. Bye.